interrupting the court, Mr. Root. Is that your signature to those documents? Is that your signature to those documents?
It is. I didn't saw it more, sir.
Are you saying you lied under oath to me?
I've never done anything.
Are you saying you lied under oath when you said, I pleaded guilty, I swear I'm guilty? Listen carefully next.
On February 13th, 2026, this defendant appeared before a Texas judge for a probation revocation hearing on two separate felony cases. Case number 18-30326 for unlawful possession of a firearm by a felon, and case number 20-34765 for assault on a peace officer. The defendant had previously pleaded guilty to both charges and had been placed on probation rather than being sent to prison, an act of judicial mercy that gave him a second chance to turn his life around. Approximately a year earlier, the defendant had violated the terms of his probation, and the court had held a hearing where he pleaded true to those violations. Rather than revoking his probation and sending him to prison to serve out his sentence, the judge had given him yet another chance and continued him on probation with specific conditions he needed to follow. One of those critical conditions was that he continue taking prescribed medications and attending appointments with his caseworkers and doctors. These medications had apparently been prescribed to address mental health or behavioral issues that contributed to his criminal conduct, and staying on them was essential to his successful rehabilitation. But when the defendant appeared for this hearing, his probation officer reported that while he had been doing well for a time and attending his appointments, he had recently begun missing them. More troublingly, the defendant had told his probation officer that he felt he no longer needed his medications and wanted to stop taking them. This was not the defendant's decision to make. A licensed physician had prescribed the medications after evaluating his condition, and only a doctor could determine whether it was medically appropriate to discontinue them. But what started as a routine discussion about medication compliance was about to spiral into one of the most contentious confrontations ever captured in a Texas courtroom.
You were charged in 18-30326 and 20-34765 with motions to revoke probation. Let's see, there's unlawful possession of a firearm by a felon in one case, and assault on a peace officer in another case. And you had pleaded true back a year ago to some violations of probation, and we have continued you on probation. So, in probation, what's the status on this one?
He right now he was doing pretty well as far as attending his appointments. He recently had been missing them, but he has rescheduled. He is set to go back on the 19th to meet with his caseworker, so he can be seen by the doctor to continue with his medications. We recently spoke, and he stated that he feels that he does not need them anymore.
Need what?
Medication.
Well, did a doctor prescribe them?
Yes.
It's the doctor that decides, not you.
And I told him I was going to let him explain what.
Because your decisions got you here.
I didn't think you just.
Your decisions got you a felony of a third degree and an assault and illegal possession of a firearm. That's what your decisions got you. Are you shaking your head? You weren't guilty?
I'm not trying to speak at you.
Yeah, you pleaded guilty to this, sir.
I didn't. I don't even want to go.
Oh, you were found guilty?
I'd rather just go by legal proceedings and let me go by my way, sir. I haven't done
Okay, we went in a trial. These were trials.
Honestly, this wasn't my case, but it happened to me.
Yeah, I see.
I see. Legal proceedings. I haven't done anything wrong. I don't want to.
I'm sorry, you're interrupting the court, Mr. Root. You pleaded guilty. You pleaded guilty to assault on a peace officer. I've got the papers. Is that true or not? I'm speaking to you on my probation.
Anyone, sir?
Sir?
I have never assaulted anyone. There's cameras in the hospital.
The hearing began with the probation officer explaining that the defendant had been doing fairly well, but had recently started missing appointments and had expressed that he no longer wanted to take his prescribed medications. When the judge pointed out that it was the doctor who prescribed the medication and therefore the doctor who should decide whether to discontinue it, not the defendant became immediately defensive and combative. The exchange that followed revealed the depth of the defendant's denial, and set the stage for what would become a perjury crisis. When the judge attempted to remind him that his own decisions had led to his current predicament, the defendant flatly denied any responsibility. The judge's patience began to wear thin as he pointed out that the defendant's choices had resulted in 2 felony convictions, third-degree assault and illegal possession of a firearm. The defendant responded by shaking his head in disagreement, which prompted the judge to ask directly whether he was claiming he wasn't guilty. What came next exposed a fundamental contradiction that would doom the defendant's position. The defendant began making incoherent statements about wanting to go by legal precedents and proceed my way, suggesting he had been influenced by jailhouse legal theories that he believed could somehow undo his convictions. When the judge tried to clarify what the defendant meant, the defendant interrupted repeatedly, claiming he hadn't done anything wrong. The judge, clearly losing patience with the constant interruptions, cut through the confusion with a direct question. "You pleaded guilty to assault on a peace officer. I've got the papers. Is that true or not?" The defendant's answer was stunning. "I have never assaulted anyone." This claim was particularly brazen given that, as the record pointed out, there was a peace officer named Cameron who had been hospitalized as a result of the assault. The defendant was now claiming under oath in open court that the guilty plea he had previously entered, also under oath, was false. This created an impossible legal paradox. If the defendant was telling the truth now, then he had lied under oath when he pleaded guilty to a crime he didn't commit. If his original guilty plea was truthful, then he was lying now by claiming innocence. Either scenario constituted felony perjury, and the defendant had just committed it in front of the judge on the record, with witnesses present.
Hold on. Hold on. We got a problem here. Did he plead guilty?
Of course he did, Judge.
Here, give this to me. Is that your signature to those documents? Is that your signature to those
What are
documents?
you asking? Like,
Is that your signature to those
It
documents?
is. I didn't.
It is?
Didn't assault anyone. I didn't assault anyone, sir. I could go about the legal proceeding. I don't want any problems. You have a problem with me?
No, you've got a
No,
problem.
I don't have any problems.
Yes, sir, you,
Go by
I
my
believe, are you going to continue to interrupt this court? You can't speak over the court. That's the rule. This lady can't take 2 people, Mr. Rude. We learned that in kindergarten. The document you signed states, among other things, I give up my right to a jury trial, my right to the appearance, confrontation, and cross-examination of the witnesses. I have read the charging instrument. My attorney has explained it to me. I committed each and every element alleged. I am giving up my right to confidentiality of the pre or post-sentence report. Agree that it may be publicly filed in the papers of this case. Listen carefully next. I am guilty of the offense and all lesser included offenses charged against me in this case. Here's my favorite part right here. I swear that all of the foregoing as well as the testimony I give is the truth, so help me God. There's your signature, sworn to. Are you saying you lied under oath to me?
I've never done any.
Are you saying you lied under oath when you said I pleaded guilty, I swear I'm guilty?
You want me to answer now? I've never done no.
Recognizing the gravity of what was unfolding, the judge took the extraordinary step of having the court clerk retrieve the defendant's original plea documents. When the paperwork arrived, the judge posed a simple, direct question. Was that the defendant's signature on the documents? After a brief attempt to evade the question, the defendant was forced to admit that yes, the signature was his. But even as he acknowledged signing the documents, he continued to insist he had never assaulted anyone and rambled about legal proceedings, claiming he didn't want any problems with the court. The judge's response cut through the deflection. No, you got a problem. When the defendant persisted in interrupting, the judge delivered a sharp rebuke about basic courtroom decorum. The court reporter cannot transcribe 2 people speaking at once, a rule the defendant should have learned in kindergarten. The judge then methodically read aloud from the sworn plea document, emphasizing each provision that made clear the defendant had knowingly and voluntarily admitted guilt. The document showed that the defendant had waived his right to a jury trial, his right to confront witnesses, and had acknowledged that his attorney had fully explained the charges. Most critically, the plea stated in the defendant's own words, "I committed each and every element alleged, and I am guilty of the offense and all lesser included offenses charged against me in this case." The document concluded with what the judge called his favorite part, a sworn oath. "I swear that all the foregoing as well as the testimony I give is the truth, so help me God," followed by the defendant's signature. The judge looked up from the document and asked the question that would seal the defendant's fate. "Are you saying you lied under oath to me?" Despite being cornered by his own signed, sworn statement, the defendant doubled down on his denial, insisting he had never done no such thing. There was no more room for ambiguity. The defendant was now explicitly claiming that his sworn guilty plea, made under oath in open court, with full knowledge of the rights he was waiving, had been a lie. By making this claim, also under oath, the defendant had committed felony perjury. One of these sworn statements had to be false, and either way, the defendant was guilty of lying under oath in a judicial proceeding. What had begun as a routine probation violation hearing over missed appointments and discontinued medications had just transformed into a potential felony perjury case that could add years to the defendant's prison sentence.
All right, I asked the state of Texas to look into perjury because that ruins all of the 98% of all the proceedings we take up are based upon these documents under oath. And if you're saying this is not accurate, you signed it, you have committed perjury. I asked the state of Texas to look into that and get back with the court. Yeah, if this is taken lightly, then 98% of what we do in this room becomes a joke, becomes based upon false statements, and that's not what this court stands for. Honor. And I expect when you swear under oath, you to tell the truth. And when you come back later and say, "I never did this," then you're responsible. You're going to be held responsible. Perjury is a felony offense, and that also is something that will affect your probations. I asked the state of Texas and the probation office to send me an updated memo, and we may need to amend these motions to revoke probation. This will not happen on this court's watch. You don't plead, you make admissions under oath and then come back later and attempt to say those were all false. That's dishonorable, it's illegal, and you will be held accountable. What do you have to say? Anything on that?
At this point, Judge, I wasn't present for.
I know you weren't.
Present stuff, so
I know you weren't, but we're not going to make a sham out of these proceedings. This is what you have done is just insulted the Constitution of the United States. Because that's what this is all about, is the way we proceed here.
Do I read my notes here correctly that we'd had a prior hearing on this that you held in abeyance, and one of your conditions was that in order for him to remain on probation, that he must take his meds? And my understanding is he's not taking his meds.
I don't know if he is or not.
Right now, because he missed his last appointment, I don't believe he has any medications. He has to meet with the caseworker first.
Try that in the, amend the motion to include that. We'll take all of that up, and this court will do it formally, not based upon his word.
Thanks, Judge.
The judge's fury was barely controlled as he explained why the defendant's actions threatened the foundation of the entire justice system. He immediately directed the state of Texas to investigate the defendant for perjury, emphasizing that such conduct ruins the court's proceedings because 98% of all cases are resolved based on sworn documents like the guilty plea the defendant had signed. If defendants could casually dismiss their sworn statements as lies without facing consequences, the judge warned, then everything the court does becomes a joke, becomes based upon false statements. The legal stakes were crystal clear. Under Texas Penal Code Section 37.02, perjury becomes a third-degree felony punishable by 2 to 10 years in prison when committed during or in connection with a judicial proceeding. The defendant had made sworn statements when he pleaded guilty, and he was now making contradictory sworn statements by claiming he never committed the offenses. One set had to be false, which meant he had committed felony perjury. The judge ordered both the prosecution and probation office to provide updated information and indicated that the motions to revoke probation would likely need to be amended to include the new perjury allegations. The judge's final statement captured the moral outrage of the moment, allowing defendants to make sworn admissions and then later claim those admissions were false would not happen on his watch. Such conduct was dishonorable, illegal, and would result in accountability. When the defense attorney attempted to explain that he hadn't been present for the original plea proceedings, the judge cut him off. The attorney's absence was irrelevant. What mattered was that the defendant had just made a mockery of the judicial process and, in the judge's words, insulted the Constitution of the United States by treating sworn oaths as meaningless. The defendant had walked into court facing routine probation violations for missing appointments and stopping his medications. He was now facing felony perjury charges and about to learn exactly how many years he would spend in prison.
All right. Let's get this done as soon as possible. Get a resetting from this lady.
Over, fine.
Mark Thibodeau. Come on up. Oh, that man is in a very unstable position right now.
That's why we have.
He was very volatile, and you can see shaking. He's an angry person, and and defiant. But
Somebody.
yeah, I mean, when you plead guilty under oath and then you come back and say, I'm not guilty of anything, you're going to have problems with the court. I mean, oath, if we can't rely on the oath and have consequences of it, then
But Judge reported though.
I think you may have offended
this is all meaningless, and
that's-
this is got to be worth a lot. This is worth something, the way we do things, especially with a 93% success rate on probation.
After the defendant was led out of the courtroom, the judge took a moment to explain to those present why he had reacted so strongly to the defendant's claims. He noted that the defendant was in a very unstable position right now and described him as very volatile and visibly shaking with anger. The judge observed that the defendant was an angry person and defiant. But then the judge explained the deeper principle at stake. When you plead guilty under oath and then you come back and say, I'm not guilty of anything, yeah, listen, you're going to have problems with the court. I mean, if we can't rely on the oath and have consequences of it, then this is all meaningless, and this has got to be worth a lot. This is worth something. The way we do things, especially with a 93% success rate on probation. This statement captured the fundamental crisis the defendant's perjury created for the entire justice system. The American criminal justice system processes millions of cases every year, and the vast majority, including 98% of cases in this particular court, are resolved through guilty pleas rather than trials. These pleas are accepted by courts based on the constitutional requirement that they be knowing, voluntary, and supported by a factual basis. Judges rely on defendants' sworn statements that they are guilty and that they committed the acts alleged in the charging documents. If defendants can later claim those sworn statements were lies without facing consequences, the entire plea bargaining system collapses. Courts would have to hold trials in every case because no guilty plea could be trusted. The defendant in this case had been given extraordinary leniency by the judge. He had committed serious felonies, unlawful possession of a firearm by a felon and assault on a peace officer, and had been placed on probation rather than sent to prison. When he violated that probation a year earlier, the judge gave him another chance and continued him on probation with conditions designed to address his underlying issues, including taking prescribed medications. And now, rather than simply admitting he had slipped up by missing appointments and wanting to discontinue his meds, violations that might have resulted in additional conditions or a brief period of incarceration followed by reinstatement on probation, the defendant had chosen to burn down his entire case by claiming he never committed the crimes in the first place. This was not a strategic decision made on advice of counsel. This was an emotional, irrational outburst from someone who, as the judge noted, was mentally unstable and angry. The defendant's statement that he wanted to go by legal precedents and go by my way suggested he had been influenced by sovereign citizen ideology or jailhouse lawyer advice that led him to believe he could somehow undo his guilty pleas by claiming they were false. What he failed to understand was that even if a guilty plea is later determined to have been involuntary or unintelligent, the remedy is to withdraw the plea through a formal legal process, not to stand before the same judge who accepted the plea and claim under oath that the previous sworn testimony was a lie. By committing perjury in open court, the defendant had given the prosecution a new felony charge to file against him, provided clear evidence for revoking his probation on both existing cases, and demonstrated to the judge that he was exactly the kind of dangerous, unstable individual who should not be allowed to remain free in the community. The judge's reference to the defendant being volatile and shaking with anger supported findings that would be necessary to revoke probation under Texas law, specifically that the defendant posed a danger to the community and that no conditions of probation could adequately protect public safety. The mention of Cameron in the hospital was particularly damning because it suggested that the peace officer the defendant had assaulted had suffered serious injuries requiring hospitalization. Assault on a peace officer is already treated more seriously than ordinary assault under Texas law, but when the assault causes serious bodily injury, it can be enhanced to a first-degree felony. For the defendant to stand in court and claim he never assaulted anyone when there was a hospitalized victim was not just perjury, it was a display of callous disregard for the harm he had caused. The judge's commitment to maintaining the integrity of sworn testimony reflects a core principle of the American legal system that dates back centuries. The oath is what separates testimony from mere conversation. It invokes divine and legal consequences for falsehood and creates a record that can be relied upon by courts, parties, and the public. When the defendant swore, "So help me God," that he was guilty, he invoked the most solemn form of promise recognized in Western legal tradition. To later claim that oath was meaningless was, as the judge said, an insult to the Constitution and everything the court system represents. The defendant's case was reset for a future hearing where the state would present evidence of his recent violations, including missing appointments, discontinuing medications without medical authorization, and most seriously, committing perjury by falsely claiming he never committed the offenses he pleaded guilty to. The probation office would provide updated information, and the prosecution would have the opportunity to file new perjury charges. And when all of that evidence was presented, the defendant would almost certainly find himself looking at revocation of probation on both cases, meaning he would serve out his original sentences in prison, plus additional time for the new perjury charges. All of this could have been avoided if the defendant had simply been honest. "Yes, Your Honor, I missed some appointments. I was feeling better and thought maybe I didn't need the medications anymore, but I understand now that was a mistake and I'll get back on track." That kind of honest acknowledgement might have resulted in a warning, additional supervision, or at worst, a brief stint in jail followed by reinstatement on probation. Instead, the defendant chose to lie, to claim innocence of crimes he had already admitted committing under oath, and to insult the judge and the integrity of the court system. He will spend years in prison paying the price for that choice. Let us know if there's a case or courtroom interaction you'd like us to cover in the comments below. Thank you for watching, and don't forget to subscribe.